Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We've had a couple more updates to the docket in Blake Lively versus Justin Baldoni. Yesterday, in a motion to compel filed by the Wayfarer parties, it was revealed that Blake Lively does not want to give up her mental health/medical records and is therefore going to withdraw her infliction of emotional distress claims. According to Wayfarer, there is dispute now about whether or not those claims will be withdrawn with prejudice or without prejudice. Blake Lively, of course, wants them withdrawn without prejudice so that she could maybe bring them up again later. Blake Lively has now issued a scathing letter to the judge in response to Wayfarer and Justin Baldoni's motion to compel those mental health records. And they're once again saying this is a PR narrative and they want the judge to strike it from the record. If you recall recently, Brian Friedman's letters regarding the Taylor Swift stuff and the affidavit that he signed were struck from the record after Blake Lively's attorneys complained that it was a PR stunt. So now let's go over this new letter where they're trying to strike the motion to compel from the docket, the motion to compel document which informed the public that Blake Lively was trying to withdraw her infliction of emotional distress claims. Dear Judge Lyman, on behalf of our client, Blake Lively, we respectfully oppose the motion to compel and related filings by the Wayfarer parties earlier today. Given that the motion is a false and plainly improper public relations stunt, Ms. Lively further requests that the court deny and strike the motion pursuant to its inherent power to control material on its docket that is abusive or otherwise improper under the circumstances. Ms. Lively respectfully submits that the court may wish to consider sanctions for the continued abuse of this court's docket. The motion was filed for a single audience, the media. There is nothing for this court to compel. As the Wayfarer parties make abundantly clear in their motion, Ms. Lively voluntarily agreed to withdraw her infliction of emotional distress claims on Friday, May 30th. Ms. Lively did so in good faith to streamline the dispute in the ordinary litigation process, given the damages she otherwise anticipates recovering. So like I said before, there is still conflict here. She has not actually yet withdrawn her claim, because they're fighting over whether or not that's going to be withdrawn with or without prejudice. Wayfarer is saying if she won't withdraw those claims with prejudice, then they're going to move forward with this and they need to compel those mental health records. At least that's my understanding of what's going on here. Just remember, I'm not a lawyer. Counsel for the Wayfarer parties concede and are aware that this renders their discovery moot. But they have also been desperately searching for an angle to make a show out of Ms. Lively's decision to streamline her case. This is ridiculous. I want to put aside for a second the argument that this was all for the media, because honestly, both sides of the ball here are definitely doing things for the press. And I understand why. But the fact that they're saying that she's dropping this to streamline her case is absolutely stupid, in my opinion. All right. Given this, counsel for the Wayfarer parties attempted to seize on the parties' agreement as to Ms. Lively's withdrawal as a basis for this frivolous motion. Okay, they haven't actually agreed to anything because Blake Lively's counsel made some edits to that stipulation, which have not been agreed upon. On Friday, counsel for the Wayfarer parties proposed a stipulation to dismiss Ms. Lively's 10th and 11th causes of action for intentional and negligent infliction of emotional distress, respectively. Ms. Lively's counsel provided proposed edits to the stipulation on Sunday evening after receiving repeated emails on Friday, late Saturday evening, and early on Sunday morning, falsely and disingenuously claiming that Ms. Lively was refusing to participate in discovery and threatening to advise the court. And they say here she was refusing to participate in discovery by not immediately responding in the middle of the night, apparently. So it's fine. It's fine as long as they're doing it. But when the New York Times reaches out at some weird-ass time during the holidays on the weekend before Christmas, it's like, well, that's just normal. That's just normal. But it's fine for Blake to complain about this. And I understand these are separate parties, but the hypocrisy is just astounding. The Wayfarer parties offered no basis whatsoever for their unnecessary escalation of a mutually agreeable streamlining of claims. Shut up. Or why finalizing the method of dismissal could not wait until Monday morning. Nonetheless, in an effort to diffuse the situation and avoid unnecessarily burdening the court, Ms. Lively agreed to the stipulated dismissal and proposed modest revisions to the parties' joint stipulation for dismissal on Sunday evening. That is a huge revision, okay? That's a big deal with or without prejudice. That's not like a little tiny detail, okay? That is a big deal. So that's pretty disingenuous to me, or at least that's how it reads to someone who's not a lawyer. In conveying the revisions, counsel for Ms. Lively offered to meet and confer regarding any dispute as to the language of the stipulation, including on the parties' then forthcoming teleconference scheduled for Monday afternoon at 4:30 p.m. Eastern Time. Counsel for the Wayfarer parties, including Mr. Fritz as signatory on the motion, attended the teleconference and did not address the stipulation. To be clear, at no point during the conference did they object to or raise any concern regarding Miss Lively's proposed revisions to the stipulation. Instead, they rushed to this court to file this clearly pre written motion the minute that the teleconference concluded. Almost immediately thereafter, tabloid media began reporting exclusively on Miss Lively's shock move, claiming that she has sensationally dropped her IIED claim, quoting extensively from the motion. I will say this, I'm not a fan of how a lot of the press has handled this. They're acting like it's already been agreed to, it's finalized, she's definitely dropped it. And I hate when news outlets take public documents and then try to sell it as we're reporting on this exclusively. We have some sort of exclusive scoop or something. Like, no, it's a public record search. Get your head out of your ass. As far as tabloid media immediately thereafter reporting on this stuff, her dropping the infliction of emotional distress claims is actually a huge fucking deal. So yeah, of course people are going to jump on that really quickly. They're not going to be as fast as I am, but of course they are. I'm half kidding. But also, let's not forget that with a third-party investigation and the motions to compel regarding those materials, Blake Lively has rushed to the judge to ask him for things that the Wayfarer parties don't even have. So she recently filed a motion to compel evidence from that third-party investigation that is not in possession of the Wayfarer parties after counsel, conferred and it was relayed to them that Wayfarer does not yet have these documents or this information, because the investigation is ongoing and they're not privy to that information until the investigation is over. So again, as a standalone document, this letter might seem kind of reasonable, but in the context of everything, it just makes me very irritated. The Wayfarer party's motion should be denied and, further, should be struck. It is based on two brazenly false assertions. First, they claim that Miss Lively has refused to disclose medical and mental health information, but as counsel for the Wayfarer parties concede, that information is relevant only to Miss Lively's standalone tort-based emotional distress claims that she indicated she was withdrawing, but she hasn't withdrawn them. She hasn't agreed to whatever stipulations. To suggest that Miss Lively has refused to produce anything, either in her written discovery responses, in the parties' conference, or any time thereafter, in connection with these claims is intentionally misleading to the court and their intended audience for this false record, the public. Second, they claim that Miss Lively has refused to properly stipulate to dismissal, but that would suggest there was any discussion or mutually known dispute as to the stipulation. I mean, they filed this, end of day Monday? My sense of time over there is not great because I'm still in Australia, but this was end of day Monday to my knowledge, so they had all fucking day to go back and forth on this if they wanted to. In my opinion, there was definitely a mutually known dispute as to the stipulation. Further, the motion seeks to improperly compel documents that the Wayfarer parties lack a legal basis to obtain and seeks no relief at all as to the stipulation. Because the Wayfarer parties concede that Miss Lively has agreed to dismiss the 10th and 11th causes of action to which such discovery is solely directed, and they have agreed to the dismissal and a proposed joint stipulation to that effect, the motion does not legitimately seek any form of relief, is irrelevant to any motion currently pending before the court, and serves no legitimate purpose. Hold on. Here they're saying they have agreed, and that's not true. They did not agree to the stipulation. That's why the Lively parties are complaining about the email after email after email since Friday. Attempts were made. It was made clear that they did not agree to the without prejudice situation here. Lively's attorneys know that. As with the Friedman letter that this court previously struck, the apparent intent of the motion is to launder their public relations narrative into the press by abusing the court's docket. Ms. Lively respectfully requests that the court exercise its inherent authority to control its own docket and strike the motion as unnecessary, improper, and abusive. The court may also wish to issue sanctions under its inherent authority to deter continuing misconduct in connection with the Wayfarer party's future filings, as this court has warned against. Last, because the parties have agreed to dismiss Ms. Lively's 10th and 11th causes of action, Ms. Lively requests that the court exercise its inherent authority and authority under Rule 15 to dismiss them without prejudice. Again, this saying they've agreed is very disingenuous to me. Also, whether or not this was designed for public consumption, you're going to have a very hard time convincing me or anyone else that they're the ones who are doing something wrong when Blake Lively pulled that shit with the New York Times at the last hour. So frankly, I just don't want to hear it. We also had Wayfarer's opposition to Blake Lively's motion for sanctions, but it's pretty late at night here, and I do need to get some sleep. I'll be checking back for more updates in the morning here, and I'll let you guys know if anything comes up. Thank you all for watching, and I'll see you all soon.